read.
Senate Bill 1309 by Senator Leyva, an act relating to pupils.
Senator Leyva.
Thank you, Madam President. Good afternoon again, members. Thank you for the opportunity to present Senate Bill 1309. SB 1309 would ensure that students who are suspended from a county office of education operated school have a fair expulsion hearing and the opportunity to appeal that expulsion decision. Current state law establishes a very specific process for school districts that are seeking to expel a student. However, despite the existence of a detailed process for handling student expulsions at the school district level, current law remains silent on how expulsion should be handled by County Office of Education operated schools. There is no requirement in current law for a County Office of Education to hold an expulsion hearing or to have an appeals hearing following an expulsion. Furthermore, even if there is an appeal, the situation could arise where the county board hears and decides on both the expulsion and the appeal. This lack of clarity does not ensure that students have proper due process when going through expulsion proceedings. SB 1309 would establish a formal expulsion process for students at County Office of Education operated schools that will ensure that the rights of students are protected. This bill has no opposition and passed Senate Education Committee with unanimous bipartisan support, and I respectfully ask for your aye vote.
Thank you, Senator Leyva. Any debate or discussion? Senator Morlock.
Thank you, Madam President. Just a question for the author.
Would the author accept the question?
Yes, of course.
All right, thank you.
Without objection.
Just, I apologize.
Keeping us all on our toes. Senator Morlock.
The County of Orange has over 30 school districts, and you're saying this is a school operated directly by the Board of Education.
By the county.
By the county. And so I was trying to figure out what that meant, and I apologize for not getting to you sooner with the fun life we're having. The only schools I can think of that are operated by the County Department of Education are the juvenile schools within our probation department, and I can't think of others. Am I
That is the majority, but in some cases it's just a particular school run by the county. They are the minority of the schools that we see in all of our districts.
Okay, so it's more unique to other areas than Orange County.
Correct.
All right, thank you very much.
Welcome.
Thank you, Madam President.
Thank you. Any further debate or discussion? Seeing and hearing none, Madam Senator, would you like to close?
Respectfully ask for an aye vote.
All debate having ceased, Mr. Secretary, please call the roll.
Allen. Anderson. Aye. Bates. Aye. Bell. Aye. Berryhill. Aye. Block. Aye. Canella. De Leon. Aye. Fuller. Gaines. Galgiani. Aye. Glazer. Aye. Hall. Aye. Hancock. Hernandez. Aye. Hertzberg. Aye. Hill. Aye. Hueso. Aye. Huff. Aye. Jackson. Aye. Lara. Aye. Leno. Aye. Leyva. Aye. Liu. Aye. McGuire. Aye. Mendoza. Aye. Mitchell. Aye. Monning. Aye. Morlock. Morell. Aye. Wynn. Aye. Nielsen. Aye. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. Stone. Aye. Vidak. Aye. Wykowski. Aye. Wolk. Aye.
Please call the absent members.
Allen. Aye. Canella. Aye. Fuller. Aye. Gaines. Aye. Hancock. Aye. Morlock. Aye. Runner.
Ayes 39, noes 0. The measure passes. Next up on the file is file item 180 by Senator Leyva, SB 1385. Mr. Secretary, please read.
Senate Bill 1385 by Senator Leyva, an act relating to emergency assistance.
Senator Leyva.
Thank you, Madam President. Good afternoon again, members. SB 1385 would ensure that local agencies who responded to the December 2nd terrorist attack in San Bernardino can receive 100% state reimbursement for eligible costs. On the morning of December 2nd, 2015, terrorists opened fire with semi-automatic weapons on the nearly 100 employees of the County of San Bernardino Division of Environmental Health Services who were participating in an all-day training. This horrific act killed 14 innocent people and was the deadliest terrorist attack on U.S. soil since 9/11. As this horrible morning unfolded, our local law enforcement immediately sprang into action to protect the public. First responders were on site within minutes and provided tactical and strategic law enforcement and emergency medical services during and after the attack. Their quick and selfless response saved countless lives and prevented the already tragic attack from becoming much worse. In the aftermath of this tragic incident, the responding local agencies are struggling to deal with millions of dollars in unanticipated costs. The estimated cost of responding to the San Bernardino terrorist attack exceeds $18 million, and without further state help, our local agencies will be penalized for their rapid and comprehensive response to this tragedy. 1385 will ensure that local agencies can continue to provide high-quality services to the constituents of San Bernardino County. I respectfully ask for your aye vote.
Thank you, Senator Leyva. Debate or discussion on this item? Debate or discussion? Seeing and hearing none, is there any objection to substituting our unanimous roll call? Seeing and hearing none, ayes 39, no 0. The measure passes. At this point, colleagues, we will go back to file item 116, SB 870, Senator Roth. Mr. Secretary, please read.
Senate Bill 870 by Senator Roth, an act relating to domestic violence.
Senator Roth.
Thank you, Madam President. Colleagues, in recent years, research has confirmed that strangulation violence is one of the most lethal forms of domestic violence, and that a domestic violence victim who experiences strangulation is 8 times more likely to be a victim of homicide. In 2011, the legislature enacted Senate Bill 430, the Diana Gonzalez Strangulation Prevention Act, making California one of 39 states with laws prohibiting strangulation. Current law, however, does not separate an act of domestic violence involving strangulation from an act of domestic violence which does not. Senate Bill 870 reframes existing strangulation provisions in the felony domestic violence statute as a standalone subdivision with the same penalties as those in current law. The bill allows law enforcement to readily identify offenders who strangle their victims without creating a new offense or increasing the state prison population. This identification becomes critical throughout the criminal justice system, as law enforcement can use this information in order to assess the potential lethality of the offender. Further, prosecutors in the courts can use this information to craft appropriate sentences, and probation can use the identification to craft better programs for abusers. Finally, victims benefit from the recognition that non-fatal strangulation is the most severe form of domestic violence short of homicide. This bill has the support of the California District Attorneys Association, the California Police Chiefs Association, and the Peace Officers Research Association of California. I respectfully ask for your aye vote.
Thank you, Senator Roth. Any discussion or debate? Seeing none, is there any objection to using a unanimous roll call? Seeing none, ayes 39, no 0. Thank you. All right, members, file item 117, Senator Bell. Mr. Secretary, please read.
Senate Bill 873 by Senator Bell, an act relating to taxation to take effect immediately, tax levy.
Senator Bell.
Good afternoon, Madam President and members. This bill, SB 873, is involving the state low-income housing tax credit program, which is arguably the most successful affordable housing program in California, and it's presently oversubscribed by 2 to 1. In other words, there's $2 of request with $1 available. Additionally, these tax credits are structured in a way that is subject to federal taxation. The result of this is that 35% of every dollar California invests in this critical program actually goes to the federal government, in federal taxes. This bill, SB 873, will allow the credits to be restructured in a way that is not subject to federal taxation, bring the investment closer to $1 for $1. This bill, SB 873, will significantly increase the efficiency and value of the state low-income housing tax credits at no cost to the state. This bill has received bipartisan support. I respectfully ask for an aye vote.
Thank you, Senator Bell. Members, is there any discussion or debate? Seeing none, is there any objection to using the unanimous roll call? Seeing and hearing none, ayes 39, noes 0. Thank you, members. Moving on to file item 118, Senator Pan. Pass on file, thank you. File item 119, Senator Bell. Pass on file. File item 120, Senator Hertzberg. Mr. Secretary, please read.
Senate Bill 881 by Senator Hertzberg, an act relating to vehicles.
Senator Hertzberg.
Madam President, thank you very much. Members of this body have heard me speak on driver's licenses and traffic tickets a number of times with respect to the budget, with respect to a number of bills last year, and all I can say is I'm back. I'm back because the problem continues to persist. And what I'm trying to do with this measure is to decouple the notion of being poor with losing your driver's license. If you're a crummy driver, you lose a driver's license. If you get drunk driving, you lose a driver's license. But you shouldn't lose a driver's license because you can't afford these enormous costs associated with tickets. And so we've decoupled this. It does not in any way affect what the current law is with respect to every other kinds of adverse actions that one might take to cause them to lose a driver's license. You're just not going to lose a driver's license because you couldn't afford it. We know that the numbers, 88% through the roof in terms of impacts of losing a license have on people's work. And it's not just because they drive to work, but it's because when companies do background checks and see that you've got a lost license, it adversely affects your credibility with respect to employers. I think it's an important measure. It's yet another step on a long march to justice. I ask for your support.
Thank you, Senator Hertzberg. Any discussion or debate? Mr. Secretary, please call the roll.
Allen. Anderson. Aye. Bates. Bell. Aye. Berryhill. Block. Aye. Canella. Aye. DeLeon. Fuller. No. Gaines. Galgiani. Glazer. Aye. Hall. Aye. Hancock. Aye. Hernandez. Aye. Hertzberg. Aye. Hill. Aye. Waso. Aye. Huff. Aye. Jackson. Aye. Lada. Aye. Leno. Aye. Leyva. Aye. Liu. Aye. McGuire. Aye. Mendoza. Aye. Mitchell. Monning. Aye. Morlock. Morrell. Wynn. Aye. Nielsen. No. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. Stone. No. Vidak. No. Wykowski. Aye. Wolk. Aye.
Please call the absent members.
Allen. Aye. Bates. No. Berryhill. No. DeLeon. Aye. Wait. No vote for DeLeon.
Is he on the floor?
I thought I heard. Gaines. Galgiani. Galgiani, aye. DeLeon, aye. Mitchell. Morlock. Aye. Morrell. No. Runner. Can we call it one more time? Gaines, aye. Mitchell, aye.
Thank you, Mr. Secretary. Ayes 32, noes 7. The measure passes. Moving on to file item 121, Senator Roth. Mr. Secretary, please read.
Senate Bill 883 by Senator Roth, an act relating to domestic violence.
Thank you, Madam President, colleagues. Victims of domestic partner violence look to the courts to provide for their safety. And one of the few long-term forms of protection the courts can provide victims is a protective or restraining order. Almost every single form of protective order, both criminal and civil, provides for uniform incarceration in the event of a violation. Victims of elder abuse, family law restraining order violations, civil restraining order violations, sexual assault protective orders, stalking protective orders, all have similar levels of protection. Offenders who violate any of these orders can receive up to 1 year in county jail. Missing from that list are the words domestic violence restraining order. Currently, an offender who has been convicted of domestic violence and sentenced to prison is subject to less punishment for violating the post-conviction restraining order than all other types of offenders. Senate Bill 883 would create more uniform sentencing for restraining order violations and give victims of our most serious domestic violence offenses equal protection from unwanted contact. With this bill, felony offenders who violate a domestic violence order can receive up to 1 year in county jail. This bill has the support of the California District Attorneys Association, and I respectfully ask for your aye vote.
Thank you, Senator Roth. Members, is there any discussion or debate? Seeing none, is there any objection to using the unanimous roll call? Seeing none, ayes 38, noes 0. Thank you, members. The measure passes. Moving on to file item 122, Senator Galgiani. One moment, Senator. File item 122. Mr. Secretary, please read.
Senate Bill 907 by Senator Galgiani, an act relating to taxation, declaring the urgency thereof to take effect immediately.
Thank you, Madam Chair and members. I rise today to present SB 907. SB 907 would reinstate legislation that was passed and in statute previously. We've had a 2-year gap, but this SB 907 would provide state income tax relief to borrowers who have had mortgage debt forgiven by their lender. This bill would apply to debt discharged in the tax years 2014, 15, and 16. After a loan modification, a bank can cancel or forgive thousands of dollars of an individual's mortgage debt. Federal and state income tax laws generally define this canceled debt as a form of income, even though it's truly phantom income that the homeowner never actually sees. The federal government has already extended this relief. Now it is time for the state to follow suit. Many families who received loan modifications or debt forgiveness cannot afford to pay additional taxes on money they never actually received. I respectfully ask for your aye vote.
Thank you, Senator Galgiani. Senator Cannella, please
Thank you,
proceed.
Madam President. I stand in support of this bill. Just for the counties I represent, SB 907 will provide tax relief for 3,500 mortgages that have received modifications from the 3 largest servicers, reflecting nearly $400 million in principal reductions. Our area in the Valley and the Central Coast has been pretty hard hit by the downturn in the economy, and this, I think, bill goes a long way to help them get back on their feet. So I support this bill.
Thank you, Senator Cannella. Senator Galgiani, would you like to close?
Thank you, and I respectfully ask for your aye vote.
Thank you. Members, is there any objection to using the unanimous roll call? Seeing and hearing none, 38 aye, noes 0 on the urgency, 38 ayes, noes 0 on the measure, and the measure passes. Thank you. Moving on to file item 123, Senator Hertzberg. Mr. Secretary, please read.
Senate Bill 911 by Senator Hertzberg, an act related to American Indian education programs.
Senator Hertzberg.
I like the bill number 911. California has 22 what are called American Indian Education Centers. And these education centers establish tutorial programs, weekend programs, parenting programs, and the like, because there has been a gap with respect to the level of performance of high school students. And so what we're doing with respect to this measure is lifting the sunset, which was 2017, and making the program permanent. Ask for your support of this measure.
Thank you, Senator Hertzberg. Members, any discussion or debate? Seeing none, is there any objection to using unanimous roll call? Seeing and hearing none, ayes 38, noes 0, measure passes. Thank you. File item 124, Senator Allen not at his desk. File item 125, Senator Nielsen. Mr. Secretary, please read.
Senate Bill 950 by Senator Nielsen, an act relating to state employees.
Senator Nielsen.
Madam President, ladies and gentlemen of the Senate, this bill would create an Excluded Employees Arbitration Act. these excluded employees, which are a managerial level, most who transition up from a represented employee position, are, I would argue, kind of the forgotten souls in state government. They advance up to positions of authority and responsibility, but then they get put in a disadvantaged position. Most of their grievances are rejected after filing. They are denied by the State Personnel Board. They are a lonely voice in the wind. It's a costly process for both the employee and for the state. This outlines an arbitration process if the grievance has not been satisfactorily resolved at the 4 levels of review that are currently in place. It outlines a procedure how Cal Human Relations and the employee organization, they agree on one arbitrator and the arbitration decision and how that is disseminated. The bill orders a non-prevailing party to pay the cost of the arbitration. This is called a baseball style or loser pay mode. This procedure then, I would argue, allows some fairness. If that has not been satisfactorily resolved at those 4 levels, then this arbitration triggers. I believe that this would then give these excluded employees a voice and allow them to have at least a fair share of their grievances resolved than almost totally ignored and rejected. Give these excluded employees, our loyal employees, a voice. I'd urge an aye vote.
Thank you, Senator Nielsen. Members, is there any discussion or debate? Seeing none, is there any objection to using unanimous roll call? Hearing and seeing none, ayes 38, noes 0. Thank you, members. File item 126, Senator Lara. Mr. Secretary, please read.
Senate Bill 953 by Senator Lara, an act relating to the Central Basin Municipal Water District.
Senator Lara.
Thank you, Madam President. Members, last year in response to local complaints and media reports that brought public attention to questionable behavior and actions, I joined with other members to request a state audit of the Central Basin Municipal Water Districts Board in my district. SB 953 would implement those recommendations made by the California State Auditor's report to improve transparency and accountability for the board. Members, these are long overdue reforms to the Central Basin Board that will provide long-term stability and viability that has been lacking for years. I respectfully ask for aye vote.
Thank you, Senator Lara. Members, any discussion or debate? Seeing none, Mr. Secretary, please read. Call the roll.
Allen? Aye. Anderson? No. Bates? No. Bell? Aye. Berryhill? No. Block? Aye. Canella? De Leon? Fuller? No. Gaines? No. Galgiani? Glazer? Aye. Hall? Aye. Hancock? Aye. Hernandez? Aye. Hertzberg? Aye. Hill? Aye. Hueso? Aye. Huff? No. Jackson? Aye. Lara? Aye. Leno? Aye. Leyva? Aye. Liu? Aye. McGuire? Aye. Mendoza? Aye. Mitchell? Aye. Monning? Aye. Morlock? No. Morell? No. Wynn? Aye. Nielsen? Pan? Pavley? Aye. Roth? Aye. Runner? Stone? No. Vidak? No. Wykowski? Aye. Wolk? Aye.
Please call the absent members.
Canella? De Leon? Galgiani? Nielsen? No. Pan? Aye. Runner?
Thank you, Mr. Secretary. Ayes 25, noes 11. The measure passes. Members, we are now moving on to file item 127. Senator Bell, Mr. Secretary, please read.
Senate Bill 955 by Senator Bell, an act relating to criminal procedure.
Senator Bell.
Madam President, members, this bill, SB 955, would ensure that state hospitals' patients are eligible for compassionate release. The bill is a compassionate measure that ensures all patients are treated equally and allowed to spend their remaining months with family in a less restrictive environment than a state hospital. Now, currently, the law allows for compassionate release for our state prison inmates, and that includes state prison inmates who are receiving treatment in a state hospital. However, other state hospital patients, such as those that are not guilty by reason of insanity, incompetent to stand trial, these are not eligible for compassionate release. This creates a situation in which a patient can be in a coma and unable to receive treatment, but can't be placed in a more palliative care setting closer to loved ones. This bill would create a compassionate release program for these patients. This bill is supported by the staff that interact with these patients every day, and I respectfully request an aye vote on this bill.
Thank you, Senator Bell. Members, is there any discussion or debate? Senator Nielsen.
Madam President, ladies and gentlemen of the Senate, on its face, this measure comes from the heart, but let me describe it in greater depth. It is a process that I'm very familiar with. Compassionate release has historically been for individuals who are facing imminent death. 90 days, as diagnosed by doctors within the institution, and they then could apply for compassionate release as determined by the Board of Parole Hearings, that they may then pass their final days within the community. Well, in this particular case, an individual with a mental health issue, and it's not necessarily specific. They could be unconscious, comatose, but it doesn't speak to the fact that death is imminent. And we can be dealing with sexually violent predators or mentally disordered offenders. These are individuals who are dangerous to themselves or others, who are in need of treatment that is not available in the community. They are yet dangerous individuals who can cause harm to themselves and more than likely would cause harm to the people in the community. And they then can apply if they have the mental condition. And this will be broadly construed, I assure you, in times when our institutions are very desirous of getting people out into our community, not holding them in beds in custody. And there will be, not accidents, but purposeful placements in the community of people who are dangerous to themselves and dangerous to the people that we care about. People who get into our community with these mental health issues are those most likely to decompensate and commit crimes. And many of them are very violent when they decompensate and get into our community. This is almost a blank check for those individuals. Without further and very strict and well thought through caveats and protocols, I argue this is an extraordinarily dangerous measure. I would argue, put this on hold. Let's give it a lot more thoughtful review. I urge a no vote.
Thank you, Senator Nielsen. Senator Morlock.
Thank you, Madam President. Just a few questions for the author, please.
Mr. Nielsen, Senator Nielsen, are you willing to take a question?
I think it's Senator.
Sorry,
From
Senator Bell.
Santa Clara.
Are you willing to take a question?
Yes.
Please proceed.
Thank you, Madam President. Just a few questions. The first is this post-release plan. I just want to be clear that the court determines if the inmates or the patient's family is capable of even administering end-of-life care. Is that correct?
Well, it depends on whether that the patient is placed in a hospice or nursing home or the family members who wish to care for him. The court has to determine whether the family can take care of them. If they can't, they can go into one of those other options if that's acceptable to the court.
So then the individual could be released without the family being involved.
The family doesn't necessarily have to be involved. It could be an agreement with some individuals that care about the patient, and they can go into a hospice, for example.
Then if this individual had committed a crime that has victims that are still alive or have relatives, would those individuals be notified that this is occurring?
Yes, there's a process that goes for prison inmates for compassionate release. The process for this is the same. They will be notified. There's several hearings. There's a process that goes through hearings, and same as the current law for prison inmates for compassionate release. So there's quite a few hoops that they have to go through, and furthermore, if somebody is determined by the court to be a danger, they're not allowed to be released.
So then if that individual turns out not to be incurable but improves and is in good health, does that individual have to go back to the Department of State Hospitals?
Yes, they can, yes.
And then my last question is, does the bill deal with any of the new language for assisted suicide, or is that not applicable?
This is really applicable to they estimate approximately 100 people annually. So we're talking about a compassionate release program that affects about 100 people. What they do when they're in the palliative care, that involves assisted compassionate death program, would be a separate matter. This bill does not affect that.
All right, thank you, Senator. Thank you, Madam President.
Thank you, Senator Morlock. Thank you, Senator Bill. Senator Leno.
Thank you, Madam President. Colleagues, these are all very important questions that are being asked of the author, but I think one point that is being overlooked is that the bill requires a determination that the individual, who, keep in mind, is already seriously mentally disordered, so would not qualify for compassionate care for end-of-life decisions because the person needs to be mentally sound for that program. These are people who are not mentally sound by definition, but they must be deemed by the court to be permanently medically incapacitated. And what that means is they need 24-hour care. They are not even physically able to get themselves out of bed and to a bathroom. Permanently, physically incapacitated. I'm familiar with this because I had authored the bill that created medical parole with the same terms, medically, permanently incapacitated. But there was concern then that a criminal could still operate some criminal operation on a phone out of a hospital bed. It didn't matter that they couldn't even make it to the bathroom. They could still run a criminal organization out of their bed from a phone. The small group of people that the author is dealing with are not in their right minds. They can't do anything that we can associate with crime. And in fact, the court also must deem them be not only permanently medically incapacitated, but also not a danger to anyone. So the court has to go through many steps. This is a very, very, very narrow universe of people. It does make sense not only for the individual and his or her family in these last months of life of a person who is not mentally sound, is no longer physically sound, but also is causing the state significant costs that we could save and put to better use. You put that all together, this is sound legislation, and I would recommend an aye vote.
Thank you, Senator Leno. Senator Bell, would you like to close?
Just that the process of reviewing these cases is quite extensive. There is a process, and I think it's incorrect to state that this released sexually violent predators. It's not true. I believe that there is a process that that has to be approved by the courts in the jurisdiction where the crime was committed or the person was declared to be incompetent to stand trial by reason of insanity. So I believe there's protocols and safeguards for this program. I urge and I vote. I think we have misinformation that has been given to the Senate by various organizations about this. And if you read the bill, I think you'll see these safeguards that I'm referring to. So I urge and I vote.
Thank you, Senator Bell. Mr. Secretary, please call the roll.
Allen? Aye. Anderson? No. Bates? No. Bell? Aye. Berryhill? No. Block? Aye. Cannella? No. DeLeon? Fuller? No. Gaines? No. Galgiani? No. Glazer? Aye. Hall? Aye. Hancock? Aye. Hernandez? Aye. Hertzberg? Aye. Hill? Aye. Hueso? Huff? No. Jackson? Lada? Aye. Leno? Aye. Leyva? No. Liu? Aye. McGuire? Aye. Mendoza? Aye. Mitchell? Aye. Monning? Aye. Morlock? Morell? Morell? No. Wynn? Nielsen? No. Hand? Aye. Pavley? Aye. Roth? Runner? Stone? No. Vidak? No. Wykowski? Aye. Wolk? Aye.
Please call the absent members.
DeLeon? Hueso? Aye. Jackson? Morlock? Aye. Wynn? Roth? Aye.
Thank you, Mr. Secretary. Ayes 23, noes 13. The measure passes. Moving on to file item 128, Senator Lara. Mr. Secretary, please read.